Hey everybody, we're going to get started in just a second. We are about to go live streaming on YouTube on a little special edition here of Decoding IP to talk about stuff that is making us talk around the office, basically, like things in the news, right?
Who knew that you could spend hours on Twitter laughing at comments in the bantering back and forth? So let me just start our show today with this. There's a person associated with a particular group. Her name is Katie Fallow. Shout out to Katie. She's part of the Knight First Amendment Institute at Columbia University. In this particular group has been very active lately on a variety of First Amendment rights relating to our current POTUS. One of their recent lawsuits requested the logs for people who are visiting the White House. As you probably know, they're no longer publishing that information about the daily visitors, which has created quite a brouhaha. Today, we're going to be talking about the real Donald Trump Twitter feed.
That's right.
And the Twitter handle, which is Donald Trump's previous Twitter handle. But he's now obviously in a new position, no longer the owner of many different businesses, now our official POTUS. And he's still using this Twitter handle quite actively to talk about a variety of different things. My view is some of this is as wearing his POTUS hat. Others might disagree. But Katie Fallow and others are telling the president to stop blocking Twitter followers. And so this leads to some interesting conversations on Twitter. So going back to our initial comment, Stephen King tweeted that Trump has blocked him from reading his tweets, and he said he may have to kill himself, which is really funny given the kinds of books that he writes and the movies that are based on those books. J.K. Rowling on Twitter has responded and said, "Don't worry, Stephen King. I still have access to Donald Trump's tweets. I'll direct message you and send that information to you." So there's quite a lot of discussion going on about Donald Trump's efforts to block certain followers who are making various comments.
Right. So let's back up just a little bit, because the Twitter conversations are very funny, but they're funnier if you know the context. So as Antigone mentioned, the president has been a very, very active Twitter user for a long time and used it to great effect during the campaign. And really, there were a ton of articles about sort of his mastery of this particular technology, communications technology. Since swearing in and taking the oath of office, he inherited the @POTUS Twitter account, which was the official Twitter account of the office, used obviously by Barack Obama for 8 years, and transitioned to him. So there is an official presidential Twitter account, and which he has used, or someone in his office has used. But he continues to use his own personal Twitter account, as he did throughout the campaign.
He has 35 million followers.
Right. I mean,
it's a big account.
Yeah. And there's actually been some press, sort of side note, been some press about how many of those followers are actually real people, but that's beside the point. In any event,
half are bots.
Right. He has been tweeting out using that account. In recent days, I guess he has been known to block some people. Normally he blocks people from following them after they tweet at him something critical. And honestly, when I looked at and Ms. Fallow and her colleagues over at the Knight Foundation sent him a letter saying, hey, unblock these people. You're violating the First Amendment when you block them, because you're preventing them from engaging in dialogue. And you are the president of the United States. You are, the quintessential government actor, right? And so that's kind of what, now there's all this stuff in the news and all this discussion on Twitter. And I always get super amused when First Amendment conversations start happening, because first of all, everyone in my neighborhood starts asking me for questions about the First Amendment. And I also get super, super, super agitated with what people, and I tell this to my children all the time, like, I'm not a government actor. You do not have First Amendment rights in my house, right? And so there sort of ensue all these conversations. And I want to say, the outset of this, Twitter is not a government actor, so Twitter can have all of the policies it wants and can block users however it wants. There are
and it does in fact have policies
Right?
about the types of activities that can and cannot occur on Twitter, ways in which you can use copyrights and trademarks, and the terms of service. And if you violate any of these policies, somebody can report you, and Twitter can elect to do a variety of things to you, including strike your account forever.
Right. So Twitter, Facebook, any social media platform that's a private company, the First Amendment does not apply to them. They are not government actors. What the First Amendment does is it protects citizens from the government taking action to squelch their freedom of speech or their freedom of religion. And so the question, the sort of initial question always is this government action, right? If it's not a government action or a government actor, then, sorry, there's no First Amendment here. So what the argument here is that Donald Trump is the president of the United States. He's the quintessential government actor. Whatever he does or says in the public sphere is speech by the government, right? By sort of the fact of his office.
And there are other examples of this kind of question coming up in different contexts, like the two bans that are making their ways through the courts. There's been a lot of discussion in all of the cases surrounding those two bans about the public statements that he has made, primarily through Twitter, about the bans. He calls them bans. And the judges who keep looking at this are talking about Donald Trump's own representations about these particular executive orders and what he believes they mean.
Absolutely.
And he's acting as a government actor when he undertakes those efforts and those public discussions.
So so this question, as he has used his POTUS Twitter for some things and his personal Twitter for some things, this question continues to arise, right? Is his personal Twitter account really an official government account? Is it something where he is, and those of you who know about First Amendment jurisprudence, and I will try to explain it, is he creating what we call in First Amendment jurisprudence a limited public forum? In other words, when he posts something on Twitter and invites comment, or I guess the act of posting on Twitter basically invites comment, is he creating a public forum? Is he a government entity? Is he the government actively creating a public forum, in which case the First Amendment really does apply? Or is this just him personally tweeting, and he as a personal individual can,
as a citizen of the United States.
And there really is not a lot of law on that. Not surprisingly, Twitter hasn't been around that long, even though it seems like it's been around forever. There's not a lot of law on this. In fact, there's basically no law.
So Jennifer, let's talk about this in the context of his post-election tours, right? Where he was going to various locations around the country where he got a lot of votes and talking to people about the success and it's due to them. And there were a lot of what I'll call rah-rah rallies, right? You know, we did a great job. We did it together. Here's what I'm going to do. I'm going to build the wall, and continue to talk about the policies that he wanted to push now that he had been elected. Think about that, and let's put the Twitter discussion in context. If I were on the side of saying, look, there is First Amendment protection here, if I'm analogizing to a public space where he shows up as the president of the United States and he starts throwing people out who are, let's say, not disturbing the peace, but are voicing their different views, would it be a problem in that kind of situation? If he were showing up in a location, it was an open meeting, somebody wasn't causing a security problem, but they were showing up and voicing their dissent. Is that a First Amendment problem?
So I think that there are about 7 gazillion cases on these issues that can point you in one way or the other. I'm not sure that that's the right analogy to make to what's going on in Twitter, but to follow it for the sake of following it, changing it just a little, as opposed to the rah-rah speeches, right, which arguably were sort of campaign events, weirdly, because he did in fact declare his re-election campaign before he went out and did those. The Supreme Court and courts around the country have always acknowledged you have the ability to have time, place, and manner restrictions And also if you're at a forum where, say, you're giving a speech, but you're not accepting comment and dialogue, and someone's, a heckler starts shouting at you, you can kick them out, right? Because you are not creating a place where there's comment. Shift the analogy a little bit. So if I'm a congressperson having a town hall meeting, right, and it's open to the public meeting, and this, I think,
let's say you're talking about healthcare reform,
right,
for instance.
I kind of have to let you in, right? I can't keep you, if I'm saying, hey, I'm going to be here, I'm going to take citizen comments, I'm going to let the public have their say. And, I can certainly limit your time, right? I can say, well, because so many people will show up to talk about this, I'm giving you all 3 minutes apiece, or whatever that is. I can certainly put restrictions on the time that you can say, and I can put restrictions on, hey, I'm going to be in this hall and the fire marshal only allows 200 people in. So sorry if you're 201, but maybe you can listen from outside, right? So there are legitimate restrictions that are content neutral. But what I cannot do is start my forum on healthcare, and then once you start saying that your position is opposite mine, kick you out, right?
Or make two lines. This is the for healthcare line, or this is for reform. This
Right.
is anti-reform.
And I'm going
to only let this
Right.
line in. Right.
That's viewpoint discrimination. That arguably violates the First Amendment. I am acting as a government actor when I'm doing that because I'm your representative. Again, the analysis can get quite complicated. And I think, the questions that are going on here, the first question needs to be, is this Twitter account the equivalent of one of those kind of meetings? Is it really creating a public forum
by a government
actor? By the government, right? Or by a government actor, right? Are you, and one way to look at it is, back 8 million years ago, I worked in the Constitutional Torts Branch at the Department of Justice. And the question there is, what was this actor acting under color of law, right? Acting as a government actor. And so there is that question here. And courts have started to try, actually the Eastern District of Virginia here, there was a case that came out of Loudoun County, which is, for those of you who know Northern Virginia, it's a suburban DC, Metro, I think we call them Metro DC out there, county, where the county board of supervisors chair had a Facebook page that she maintained, and there were comments on that Facebook page that she deleted, and she blocked the user, and then she kind of rethought it and unblocked him. But it went before the Eastern District, and the question was, what is this Facebook page? She is a public official. It was her personal page, and there was a public page, right, for the board of supervisors that engaged with people. And there's a pretty deep analysis to run through, and the court basically didn't decide it on summary judgment and let it go to trial. They decided some issues, but the Judge Kacharis in the Eastern District have walked through this analysis saying, okay, when are you a public official and when are you not? And for social media purposes, it's pretty obvious if it's the official POTUS account, if it's the official White House webpage or the official White House Facebook page. You're probably creating a public forum there. There are First Amendment implications to what you can and cannot do. But what if it's your personal thing?
Yeah, so with real Donald Trump, I don't even think this is a close question. He uses his personal Twitter handle to discuss government actions, his view on world leaders, his view on what the courts are doing. He retweets from POTUS. So he mixes the two. He doesn't separate his personal activities as a private citizen on a separate Twitter account from his government activities. And my understanding is his team has sort of agreed that was
right.
the case.
I mean,
right?
Sean Spicer came out and said everything that he tweets is an official statement of the President of the United States. I think once you have the White House declaring that, it's hard to walk away from that. Right?
Yeah, so I'm going to check that box. Is he acting as a government actor, at least with some comments on the real Donald Trump handle? I think that's a check the box. Let's move on to more complicated questions relating to this discussion. and part of the complication is the technology, right? So when you talk about the fact that it's not a perfect analogy with a let's show up and talk about healthcare reform and I'm inviting all views versus what Donald Trump is doing on Twitter, where he seems to get irritated by certain people's comments and blocks them. It's not the same as throwing somebody out of a physical room where they can't voice their opinion. Anybody who has any technical competence with Twitter knows that you can basically just log out and then you can go to a web browser and look up the real Donald Trump handle and you can see the entire stream of public tweets and comments on those tweets. And so there are workarounds. It's not as if you can never, never, ever see the tweets. It's annoying because you can't interact with them through your own Twitter handle, but you frankly could set up a new Twitter handle and do the same thing, or use one of your other Twitter handles. Because let's face it, a lot of us have business Twitter handles and personal Twitter handles, or a couple personal Twitter handles. There's nothing wrong with that scenario.
I think that's right. And I think Eugene Bullock did a fairly nice breakdown of the, what does it mean to be blocked on Twitter? For those of us that don't really use Twitter, I have a Twitter handle. I don't use it nearly as much as other people might use one. So what does it really mean to be blocked on Twitter? So, okay, if you check the box and say, we think he's a government actor here, we think there's at least, First Amendment implications, right, to his Twitter account. So then what does it mean to block someone, right? And there are basically three things. One thing to block someone is they can't read my stuff. Well, as you said, that's pretty easy to get around because I can just log out and then go to a web browser and see the Twitter feed.
Or one of the social media management tools. I can just pull through the API.
I can just pull it through.
See what's going on.
I can see your stuff. So you can block me, but for the most part, I can still find that, unless you really set everything to private, and we know that he'll never do that, right? So like, it's not a private thing.
I think we can say that's not going to happen.
Yeah, he wants more than 30 million followers for sure. So okay, arguably, like I shouldn't, under the First Amendment, I as a government actor shouldn't be able to prevent you from getting information. I'm not really. You can see it. Whether the court thinks that making it harder, because there are cases that say, making it harder can violate the First Amendment. But, so there's that. The second thing is, I am preventing you from interacting with me directly. Well, the First Amendment sort of famously in First Amendment case law, there is a right to speak, there is no right to be heard, right? So there is this notion that like you can't force someone to listen to you. So I think the First Amendment implication there is kind of the weakest, right? That like, okay, so I've blocked you, so now you can't direct message me. Well, you don't really have a right to direct message me, even if I am. I mean, you don't have a right for me to listen to you. I'm not preventing you from going on Twitter and saying whatever the heck you want, right? Twitter can do that, right? Like you can talk about Donald Trump on Twitter all day long. He can't do anything about it. But I think the third, and I think where I agree with Volokh, is that the closest call here is that I am preventing you to the extent that, Donald Trump tweets something and then there ensues a giant chat stream of citizens interacting about healthcare, about, travel ban, about whatever it is that he's, official government action that he's tweeting about. I have prevented you from joining that dialogue. And that
seems like an important issue.
That's a pretty big issue, I think, from a freedom of speech and a freedom of association standpoint, right? I am basically keeping you out of the public square.
Right. Well, look what's happening in Russia right now. There are a number of different statements that have been made. There's people in the streets talking about Putin and the corruption. And one of the most famous dissidents was arrested before he even showed up to a protest that he had actually organized. And so that's the classic situation where we look at that and we say, you're chilling dissent and you're chilling speech. And if you start the ball down that road, it gets a little scary when you think about where it might go.
Right. And I think that really is the point here, right? Which is, if you are going to engage on Twitter, if you're going to engage on these social media platforms, and you are going to do it in what is arguably your capacity as the leader of the government, you are going to have to accept the fact that you can't stamp out dissent, right? That people are going to be able to comment on your things, and lots of them are going to say things that you don't like, and you just have to let it stay.
So some have said that this particular individual is not very good with shoving that stuff off, which might lead us to where we are now, right, with the blocking people.
Right? And that's really why we're having this conversation, right? I sort of, and I went round and round with some folks the other day about the implications of this, right? Because there's the should you do it and the can you do it question, and oftentimes those are not necessarily answered the same way. I think, you and I think disagree a little bit on the First Amendment and whether it applies here. I think it is a much closer call. I think I might eventually come down with the same answer as you, but I think it requires
I'll wear you down.
A deeper analysis, right? But even if not, I think my advice, if I were sitting in the office, would be like, dude, just you're making it worse, right? By blocking these people, just let it go. I do think that there should be some pause here, because I think what necessarily happens with this particular president is that people view things very much through the lens of his personality. And I mean, this is a very unique circumstance. I think any decision here on First Amendment implications necessarily then trickles down, for lack of a better term, to all other elected officials, and not just national elected officials. We're talking about county board chairs and small town mayors and that kind of stuff. And the courts, I think, have been, even outside of this technological arena, have said, look, to a certain extent, there are elected officials are not necessarily the government all the time, right? They are the government sometimes, and they are sometimes not. There's First Amendment cases that make the distinction between campaign speech and government speech. There are First Amendment cases that talk about, and a good example is sort of freedom of religion, right? So we have separation of church and state here. But courts have said it's okay if an elected official invokes whatever God they choose or don't choose in their speeches. We're not going to say that's government imposing religion, because we recognize that these people are individual humans, right? So I think it might not be complicated in your view when the actor is Donald Trump. It might be significantly more complicated when it's a small town mayor who's had a personal Twitter account for a really long time and is coming under some harassment and wants to block some people, right? I think these are a little more nuanced. And one of the things that I think is, this case is a relatively easy case, because the Twitter critics who were blocked were pretty tame and legitimate criticism people, right? They weren't people who were, tweeting out death threats and all of the kind of nasty that can come along with this.
Right. They weren't Twitter bullies.
Right. These are not hard people to defend in terms of
but you make a good point, and that is we can't just think about the polarizing or the polarized view of the real Donald Trump situation. We have to think about what effect that kind of decision would have on the ground in closer cases or situations where people really aren't acting in a government capacity, and it's not as close a call. So anything that happens, let's say that a lawsuit is actually filed, which, let's be reasonable here. There is some likelihood that there will be a lawsuit coming out of this. The court is going to have to be really careful to think about this particular situation, go through the detailed analysis that you were so kind to walk everybody through, because it is a complicated question, and it's not just an on or off, a yes or no. There are various pieces you have to consider, and the facts and circumstances of each case have to be kept in mind. So hopefully any analysis by the court will be nuanced and focused on the particular situation. And given that this is a new area and there isn't other law out there that really provides perfect guidance, the court's going to have to be really careful to make sure that it doesn't go too far and make proclamations that take us too far over the line and create this cascade effect with other technologies. Because when people can't do business using social media in a manner that can be helpful and powerful because of a court's decision that puts its thumb too far on the scale, that becomes a problem.
Right. And that, we talk about this consistently, whether it's copyright law, trademark law, patent law, various aspects of technology law. We really are always on the forefront of sort of trying to fit existing jurisprudence into a world that is vastly different than when
I call it square peg round hole.
It really is. And sometimes it's fairly easy, right? Sometimes you can kind of draw these analogies and say, well, this is roughly the same thing, right? And then sometimes it's a lot harder. And I think, educating the judiciary on how these technologies work when you have judges who probably have never been on Twitter, right? And having that conversation.
If you've never been on a platform. So you said you don't do Twitter. Twitter's one of my favorite platforms. So I'm always digesting information and interacting and looking at stuff on Twitter. So for me, it's perfectly understandable that you can get access to this information just by logging out or using another social media tool to pull this feed and any other feed that you want. No problem. It's just a small technological workaround that seems so simple to somebody who spends time on the platform.
But maybe not to everyone. And maybe, when courts have looked in other contexts and other non-technological contexts about access to information, at what point are you going to draw the line of like, we think this is an easy workaround or we think this isn't, or really there's no such thing as it's okay for you to squash speech as long as there's a workaround, right? Like, I mean, and all of that stuff.
That could set a bad precedent too.
Right. So what is enough of a workaround? Where is that line? And I think courts are going to have a hard time with that. And I think that was fairly evident. It wasn't Twitter in the Davidson case in the Eastern District of Virginia that I mentioned earlier. It was Facebook, but a very similar thing. Like, okay, well, how does this work? And what does it mean to block someone? And, is this a limited public forum when I put something out there and I'm basically inviting comments? Maybe it is, maybe it isn't. It certainly is if it's on an official page. And then the question about these, and as we are getting into an era where, for a long time, people only had Twitter accounts when they started to run for public office, right? Like, because it was a new thing. Well, now we're in a world where everybody's got a Twitter handle and a Facebook page and a this, that, and the other, right?
And the POTUS handle was turned over by former President Obama to the new president when he left office.
And so you're going to have
no longer manage that handle.
Right. You're going to have official accounts, but you're also going to have people that, this is not a question that's going to go away. It's not a question that's limited to Donald Trump, right? This is pretty much every elected official now. Once and there's a lot of stuff we have where like people sort of have a campaign and then the campaign ends because they got elected and all of the campaign stuff kind of goes dark and dormant for a while until they're running again for something. But what about these personal accounts, right? Especially if you're someone who maybe uses their personal account for all kinds of other personal non-business reasons, and you also kind of retweet your campaign stuff, and then you get elected and you're sort of doing both. I think this question is not going to go away.
Right. So not only is Donald Trump the president and now a part of the government and generally a government actor, but he had a real personality and he was a public figure and a social media influencer before he entered office. And so that makes this an interesting and unusual situation. But more and more on social media platforms, the person is the brand, right? And there are people, think the Kardashians, who make a boatload of money on their social media profiles and the things that they say about products and the things that they push. And, they're not government actors, right? But they are acting in a business sense at the same time because that is their personality and their profile has become their livelihood. So to your point, the personal and the business are merging more and more on these social media platforms for a wide variety of individuals.
They
It's not
really
just
are.
government actors.
Yeah, they really are. And if those people end up running for office, as someone was telling me the other day that Kanye West was talking about running for president, like we're going to have the
Don't
same
laugh.
issue, right? I know it's no longer a laughing thing. But no, I mean, I think this issue, I mean, it is unique because of who President Trump is, and because of sort of his nature and how these things came up. But I think that the question of First Amendment implications on the social media platforms used by public officials, it is not a question that's going to go away. It has obviously come up on a much smaller scale before, and it will continue to come up again. So we will see, I guess, what happens. I mean, maybe he'll just unblock these people and go away, but I doubt it.
Yeah. So before we finish this conversation, we should talk a little bit about the legislation that has been introduced,
yes.
which
The
going back to
confetti.
the, yeah, right. So putting the thumb on the scale, there's been legislation that has been introduced to designate Trump's tweets, all of his tweets, official government records, which means the National Archives will keep that information as part of the official government records till the end of time.
Right. And on one hand, this isn't that unusual because periodically, as methods of keeping records change, I think at some point we had to amend this statute to include emails and other things, right? So it's not super odd to have this kind of legislation, except for the fact that it's in the context that it's in. And it was cleverly acronymed. I think this particular legislator, House member from Illinois, made it the Covfefe Act. That fake word that Donald Trump tweeted, and it's
it's going to be in the Urban Dictionary in like a month.
Communications over electronic feeds for engagement and something. I think
his staff had a great time coming up with that.
Oh yeah, absolutely. And what it basically says is, hey, anything the president tweets is an official thing, and it should be recorded and kept as such. And certainly the POTUS Twitter account is set up that way. It says on the thing that it's archived, and arguably, even though it doesn't arguably fall under the statute, that's how the Obama administration treated those. And so,
and tweeted them,
right? And so this legislation would, and that actually is what led to the Sean Spicer comment when asked about this piece of legislation. Hey, are these tweets official statements? And he said, yeah, they are. And of course, then you're like,
okay. So I would just like to say, case closed. Let's move on from that question.
Right. And so,
thanks for making my point for me.
The legislation probably won't go anywhere, but eventually, I think it will have to, whether under this president or another one, because if this is how you're going to choose to interact.
Well, he recently announced his new nominee for the FBI on
over
Twitter
his Twitter account,
for the first time, right? So that's the official announcement of his desired replacement for James Comey.
Right, and it's, I mean, you can hearken back to the very first radio addresses, right, where this is just
a fireside chat,
right? This is just yet another way of communicating. The president is now using this much more than the prior president used, although the prior president used it too. To do this, he just so happens to be really commingling his personal and his POTUS handle. And I think the result of that will be that ultimately these get preserved in the way that other presidential communications get preserved. And I think we will be dealing for a really long time with First Amendment implications of his personal Twitter handle by his own making, right? Because he certainly could have, once he assumed office, he could have stopped using that account and only used the POTUS one. He could have continued to use that account, but only really in a very personal way. He could have been tweeting about, his wife and kids and a dog and his meals overseas. I mean, that would have been a very different thing, arguably not really appropriate, but he could have. And then I think the argument is a lot harder to make that there's First Amendment implications there, right?
So Jennifer, we always like to bring this back to the everyday person, right? And particularly businesses that are learning to use I'll call it new technology, even though it's not new technology. But these platforms to communicate with other businesses or consumers, whether they're B2B or B2C or what have you. What are the takeaways that they get from this discussion, right? So the government actor piece doesn't necessarily apply to them, but there are things that businesses should be thinking about on these platforms, and this kind of conversation around First Amendment issues is an interesting context, because businesses sometimes try to get rid of tweets or Facebook discussions that are disparaging of their products or their companies, and there has been litigation over this particular
that
issue.
go the wrong way. Yeah, I mean, you know, as I said at the outset, if you're not a government actor, it's not a First Amendment problem. Lots of people may claim that their First Amendment rights are being violated by a private company, but they're really not. It's not a First Amendment problem, you know. But then that question comes, well, they're intersecting issues for businesses, right? Because one is brand protection.
And the goodwill associated with your business.
Right. So there's brand protection and there's goodwill. And it's sort of the same thing that we talk about in the context when we talk about things like cease and desist letters. Sometimes it's better just to let things roll than
right. You can cause a bigger firestorm by deleting something, and then you have an angry person who is trying to comment either positively or negatively. And you've created a bigger monster.
And so that, I think, the big takeaway from the kerfuffle going on over Donald Trump and blocking people is, if you just would have let it go, nobody would have ever read those tweets, really. I mean, it's you know, like, now it's a big deal. Now it's a national discussion. Now there's a potential lawsuit, right? You're drawing all of this attention that, you know, you wouldn't have.
It's the Streisand effect,
right? It really is. And so I think, you know, for businesses out there thinking about how they use their social media, you know, sometimes blocking the people isn't really the best way to go. I've seen a lot of businesses be very clever and use humor to kind of diffuse it, which is, especially on Twitter, which is a world of humor, can be helpful. I think ignoring it sometimes is equally helpful. But I think some stuff is bad enough that you want to deal with it, right? And there are different ways and different strategies that can help you deal with things that you don't necessarily like and protect your brand, and go after things that are disparaging to your brand in a way that hopefully won't give rise to this kind of public discussion.
Well, I'm sure we're going to have updates on this topic as things continue to roll out, but for our viewers and listeners, if you have any questions about some of the law and technology issues, whether IP or other legal issues associated with use of these social media platforms, this is an area we spend a lot of time working on and talking about with our clients, and generally discussing over lunch here. We're big nerds when it comes to these topics, particularly when we're ripping stuff from the Hollywood Reporter and other headlines. You know, there's some really interesting issues arising on the social media platforms. So please give us a call if you want to chat about these topics, and also let us know if there's a topic that you're interested in and you're seeing in the news and you want us to cover on a future show. We're always looking for new topics to cover, and love to talk about things that are in everyday news, break it down from a plain English perspective so people understand the IP and technology law issues associated with those topics.
Yep.
So Jennifer, thanks for joining me as
Thanks,
always.
it was fun.
If you want to hear more of our shows and our podcast, you can find us on Google Play, the Apple Store, on the Decoding IP channel. You can find us blogging and also our multimedia on decodingip.com. Follow us on Twitter at DecodingIP. And thanks for listening, and we hope to see you again soon.